And it's 9 o'clock. So good morning and welcome to an oral argument session of the 5th District Court of Appeal. We have one case on the docket here at 9 o'clock. My name is Rand Wallace. I'll be presiding over the oral arguments today. Also joining me on the panel from our court is Judge Jim Edwards from Seminole County and Judge Meredith Sasso from Orange County. I would just ask that the parties, if you have any devices that could make noise during the OAs, that you would just please put those on silent so that it doesn't distract whoever's presenting. And when you're not speaking, to make it easier, just mute your microphone when you're not speaking. I will assume, Mr. Fredrickson, that you want 5 minutes for rebuttal unless you tell me otherwise. We can adjust that based upon your preference. And other than that, I will just allow you to begin your presentation. Mr. Fredrickson, you may begin.
Good morning, Your Honors, and may it please the court. Blake Fredrickson here on behalf of the appellants, Amy and Dan Rooks. And I would like to change the 5 minutes a little bit and reserve 7 minutes for rebuttal, if it would please the court.
You got it.
This case, in our view, is about physical and legal impossibilities. At trial, the plaintiff changed, and I'm going to use the term plaintiff interchangeably here, but when it makes a difference, I will bring that up. The plaintiff was originally Wilmington Savings, and I'm going to shortcut that. I think you guys read the briefs. And at trial, literally the first discussion at trial, even after it started, plaintiffs had already introduced themselves, witnesses had already introduced themselves. The plaintiff, again, Wilmington, says that we would like to change, substitute the party plaintiff for U.S. Bank as a trustee for who was the current appellee. The appellants objected every way that we know how to object. The plaintiff at the time said that, well, appellants knew about this assignment, therefore they can't be prejudiced. And even more importantly, which brings me to my really synopsis of this case, is that the plaintiff says and continues to say in their answer brief that, Judge, you don't have to grant this motion to substitute the party plaintiff. If you deny it, it's fine. And what we say is, well, Judge, if they're saying that it doesn't make any difference to them one way or the other, then we're asking you to deny the motion. And the judge says, well, explain prejudice to me. And as I did specifically in the reply brief, laid out all the different things that we were prepared to challenge if, in fact, it was the original plaintiff. Yes, of course, a big portion of our case was going to be based on the fact that we had a power of attorney that we discovered a week before trial that apparently the plaintiff either didn't know about or didn't want to tell the judiciary about. But at least according to them, it didn't make any difference one way or the other. So our initial position, Your Honors, is that the court erred in granting that motion to substitute the party plaintiff when there was no prejudice, admittedly, by the plaintiff, the appellee. There's also this idea that is part and parcel with the substitution of the plaintiff, which is the simultaneous standing notion. What the appellee would have this court accept is that unrelated trusts or unrelated banks acting as trustees for unrelated trusts with actually a different servicer somehow could have simultaneous constructive standing of a negotiable instrument. That can't be possible. Perhaps it could be possible in simultaneous standing if you have an upstream or downstream, you have a real party interest and a servicer, but you could never have simultaneous standing based on a constructive possession case when you have unrelated parties. And that's what—
Counsel, who are you saying had physical possession?
Would have been either the law firm or the servicer, Rushmore.
Well, I thought the law firm is the one that filed the certificate. Am I mistaken about that?
No, you're correct.
Okay, so the law firm had it the whole time. They had physical possession from the time suit was filed until final judgment was entered. Is that correct?
Well, it was filed with the court, but
Right. No, I understand. Once it was filed with the court, then that's fine. But I mean, from the time suit was filed until the time trial started, the same law firm had possession of it, correct?
yes, on behalf of Wilmington.
On behalf of Wilmington, and then once the parties were substituted on behalf of U.S. Bank's trustee, correct?
Well, the note had already been tendered at that point. I think that might be a semantics issue.
Okay, but I mean, that to me, that kind of answers your questions of how can that be done simultaneously? It wasn't the custodian who changed, it was the party plaintiff that changed, actually. Isn't that true?
That's true, but that does not address the problem with the plaintiff's representations at trial and even in this appeal, that you didn't need to grant. Either one of them could have foreclosed. Either one of them could have foreclosed. So that doesn't address that issue, Your Honor. I understand what the court's saying, but it does not address the problem with simultaneous standing. That's subsequent standing. It was assigned, and that would be the traditional way to look at it. They're not saying that. They're saying we had standing at the same time. Judge granted or denied, doesn't matter. We're going to win anyway because we got Rushmore and we hold the note, more or less. And I think that's what they're saying. Some compilation or some unwashed machination of the law firm and the servicer. So I think that it's a little bit different, but I understand the court's point though.
Well, Mr. Frederickson, in any of these foreclosure cases, the concern is always based upon the big influx of foreclosures in the past. Do you have the note that created the debt obligation? Is it the same note? Has it been altered? Do we have any concern about the reliability of the note? Did you raise any concern as to the accuracy or any alterations or ambiguity about whether or not this was the actual note that was in possession of the party that filed the lawsuit and also the party that ultimately took the case to trial? It's the same note, correct? There's no concern over the accuracy of the note.
I think that's a fair statement. I wouldn't say there was no concern, but I don't think that we preserved that issue for this appeal. I would agree with you. We didn't bring that up at trial.
And the note was endorsed in blank, correct? Entire time that all the parties recognized the note was endorsed in blank. Okay, correct? Yes, I certainly at the time it was tendered. Yeah, I would agree with that. So you're challenging the parties, but you're not challenging the fact that in both of those instances, at the time of filing and then also the time of going to trial, that the party that was presenting itself in the filing as the plaintiff, and at the time of trial, the attorney representing the plaintiff had the actual note, correct?
Correct, but the plaintiffs weren't there. They've never been there. I mean, I think that's an important point to make. It sounds a little silly, but the plaintiffs were never there. The only people involved in this lawsuit were servicers, and the one servicer and the actual law firm itself. So you could make the argument of the rules of judicial administration that the plaintiff's law firm is representing the plaintiff, therefore they're an automatic agent of the plaintiff themselves. But they weren't. There was no evidence whatsoever that the law firm's acting as an agent for the new plaintiff. And on top of that, there was no evidence whatsoever that the servicer was acting as for the new plaintiff. None. They didn't even suggest that. The word
isn't your argument really challenging though the representation and not the standing? I mean, how do you distinguish? Let me ask this: how do you distinguish this U.S. Bank case from the 4th DCA, the 2022 case that's cited in the answer brief?
Is that the Karachi case?
U.S. Bank versus Grob.
I'm sorry, I have that highlighted and brief. Just give me 1 second, man. Well, one, in Grob, we're talking about a written motion. Okay, so I think that the substitution situation would be different, and that's an important point. And this brings me to the point I'm making, and this is how it's distinguishable. We're talking about a written motion done before trial. So therefore, 1.260 controls. It says that if you make a showing that there should be a substitution, by written motion, then they can substitute, and standing will be, you sit in the shoes of the original plaintiff. Here, we never had that. We never even had a presentation of any evidence. We were the ones, we being the appellants were the ones that filed discovered and filed the assignment of mortgage, which changed the real party in interest. It wasn't entered as an exhibit at trial. It wasn't even, the witness didn't even testify that he was there on behalf of the new plaintiff. They just said plaintiff as if it's all along. So I think it's distinguishable first in the grounds that we had a traditional substitution of party of plaintiff written motion. And even if it was decided at trial, the intent of that, there was no prejudice and couldn't really be any prejudice on behalf of the appellants in that particular case. Here we have, those are the two distinguishing factors, that we have prejudice to the appellants in the sense that the case that was tried, there was no indication that the plaintiff was going to change the name of the plaintiff at trial. None. There was no 1.260 motion. There was no filing of evidence that would support that. Indeed, there was the opposite. There was the filing of the power of attorney. There was the trust agreement. I can't think of the phrase that escapes me right now, but the agreement whereby it delegates that which loans are included within which trust. And all of that was directed at Wilmington.
Counsel, is the holder of a note that's endorsed in blank entitled to foreclose?
If they demonstrate standing at inception and at trial, yes.
And here you have the counsel for the plaintiff, the initial plaintiff, held the note and filed a certificate, and the copy of the note attached to the complaint is identical to the actual note entered. So that's typically evidence that the plaintiff had the note either personally or constructively at the initiation of the suit, correct?
Yeah, under Ortiz, yes.
Okay, and then once the original note and mortgage are filed and accepted into evidence, and I believe, was that with or without objection here?
Are you talking about the affidavit or the note?
The note, the original note.
Without objection. It was without objection.
Okay. And was there any evidence that the holder of the note was anybody other than the substituted plaintiff?
Yes. I guess I would argue that it was Rushmore. Rushmore or the counsel for plaintiff, yes. We would argue that.
But one or the other was the holder of the note on behalf of the new plaintiff. That's the argument that was made, correct?
Yes. The argument was that it doesn't matter. It doesn't matter who it was because it was one or the other, and it's okay because the real parties that you need, Judge, are here, which is the law firm and the servicer. That's what they're saying. I mean, we represent these. That's what they're saying. We represent these real parties in interest. So it doesn't. You substitute one.
Under Florida procedural rules, must the case be prosecuted by the real party in interest, or may it be prosecuted by the real party in interest? Is it mandatory?
No. There could be an agent that could prosecute it, but I think there should have been here. And I think that's my point. I understand what the courts say, but I really want to drone down on the fact that this is a constructive possession case brought by an agent. I think it was likely that the plaintiff could have prevailed in this case without the substitution of party plaintiff, if that assignment of mortgage that we discovered did not exist. I think they probably.
I mean, wasn't your argument the same though before the substitution? And that kind of goes back to the prejudice. I mean, the theory of the case was going to be standing regardless, correct?
It was standing and then attacking the agency relationship and lack thereof. Yes, but ultimately that all cycles back to a standing argument. But yeah, it was the attack of the agency relationship, because what we were going to do, and even at the risk of this court reverses, we're going to go in front of a new trial, potentially new trial. And I'm saying what the argument was, but the argument was that Look, you're suggesting that you're acting as an agent on behalf, and you have the authority to act on behalf of this real party in interest. However, this real party in interest hires a separate servicer and then and assigns that this note to a third party that you don't even know. And on top of
And
that,
Mr. Frederickson, you're into your rebuttal time. I just wanted to let you know that.
okay, I will reserve the rest of my time for rebuttal. Thank you, Your Honor.
Okay. All right. Mr. McKeever, you may proceed.
Good morning, Your Honors. May it please the court. I'm Richard McKeever for U.S. Bank as trustee for the RMAC Trust, which I'll refer to as the bank in this argument. There are two issues raised by the briefs. First, whether the trial court properly allowed substitution of the bank for Wilmington at trial. Second, whether the bank demonstrated standing to foreclose at the inception of the case and at trial. Now, the first issue is governed by Rule 1.260C, which provides that upon the transfer of an interest, the action may be continued by the original party unless the court, upon motion, directs the transferee to be substituted in the action. The rule is permissive, subject to the discretion of the court. At the trial in this case, the plaintiff was prepared to proceed in the name of the original plaintiff until it became clear that the appellants were going to object based upon the assignments of mortgage filed with the court minutes before the trial began. The bank at that point made an ore tennis motion to substitute the transferee bank pursuant to the rule, which was granted over the objection of the appellants. The court considered the assignment of mortgage into the bank when granting the motion. Now, the appellants were not able to point to any prejudice the substitution might cause, especially in light of the fact that Rushmore was a servicer for both Wilmington and the bank. The same witness testimony and business records would have been presented at trial, regardless of which entity was the plaintiff. The appellants did not seek a continuance of the trial on this basis. They sought a continuance early on other grounds, but not on this basis. And thus the court did not abuse its discretion to permit the substitution of the bank for Wilmington. There is prior precedent that motions to substitute may be made at trial for the SERP and the Johnson cases. Further, this court has made it clear in the Bo-Chan case that a substituted plaintiff stands in the shoes of the original plaintiff and acquires the standing of, if any, of the original plaintiff mortgagee. Because the plaintiffs were obviously aware of the transfer of the loan prior to trial, having filed the assignments with the court, because they did not seek a continuance to obtain further discovery or for other purposes, they could not point to any prejudice that would occur by such substitution. They can't be surprised at trial that such substitution was sought because they knew at the time of trial of the assignment. The trial court therefore did not abuse its discretion permitting the substitution, and the order substituting the bank at trial should be affirmed.
Mr. McKeever, the appellant keeps saying that there was no evidence that Rushmore was the agent for the bank. What do you have in response to that?
Yes, page 42 of the transcripts, the witness said, "We are the servicing agent for the plaintiff at this time." And at that point, the plaintiff had been substituted. So I take that as testimony to mean that Rushmore was the servicing agent for the bank.
Okay.
On the second issue, the final judgment should be affirmed because the bank demonstrated standing to foreclose at the inception of the case and at trial. The unrefuted testimony at trial was that an original blank endorsed note was delivered to Wilmington's attorneys prior to the case being filed, and a copy of the note was attached to the complaint. The court took judicial notice of the complaint, which included a certification of possession of the original note. There was testimony of an employee of the law firm who provided evidence that the original note was received in May 2018, 4 months before the case was filed in September of 2018. At trial, the original note was offered into evidence and it bore the same blank endorsement and was identical to the copy of the note attached to the complaint. The bank demonstrated that it had standing as the holder of the note as provided by Florida Statute 673-3011 sub 1 as the person in possession of the note endorsed in blank. This court's cases of Glicken, Centurion Systems, and Bo-Chan, and many others from the other districts are all on point when the note with an undated blank endorsement has been attached to the original complaint, this is sufficient to prove standing if the plaintiff produces the original note at trial or files it with the court and there are no subsequent contrary endorsements. As this court said in the Glicken case, the law favors negotiability, and the court should be reluctant to adopt rules that burden transferability of negotiable paper. Now, no power of attorney or other document is necessary to prove foreclosure, as stated in the Clark and Heath cases cited in our answer brief. And as the court has pointed out this morning, the servicer's involvement does not diminish the authority of the holder of the note to foreclose per the Grob, Tacarante, and Petrov cases. In summary, the court acted within its sound discretion to allow the substitution of parties, and the bank proved standing at the inception of the case by Wilmington and its own standing at trial by producing the original note with a blank endorsement that matched the endorsement attached to the complaint. Therefore, the judgment on appeal should be affirmed. Thank you.
Thank you, Mr. Frederickson. You may proceed.
Thank you, Judge. I'm sorry I was muted there for a minute. I'm sure I said something brilliant.
That's all right.
I want to first address the in inverse order there. When my colleague here was asked whether or not there had been evidence that the servicer, in this case Rushmore, was acting on behalf of the new plaintiff, he referred to page number 42 of the transcript, and he reads off the question, but then doesn't read the next line, which is, Mr. Frederickson, objection to the statement as to the statements that Rushmore is the servicer of this loan. We object as to hearsay, foundation, and predicate. The judge overruled that. There were similar objections made on page 13, 42, 52, 53, 56, 57, and 60. This case held in the Cook v. Bank of America case, a case I took up on appeal, that the witnesses that unless if the witnesses in knowledge is based upon business records, in this case it would be, because the witness was not a precipient witness to anything, that if a business record is not entered into evidence, i.e. in this case a power of attorney or an SLS or something else that would establish the agency relationship, that testimony should not be considered by the court as it is inadmissible hearsay. And I think, look, the bank knew that they had to establish the agency relationship was challenged. It was challenged in the answer and affirmative defenses. The bank brought what they needed to establish the agency relationship as it relates to plaintiff one. They brought it. It was in their exhibits. It was in, I'm sorry, the power just went off my office, but sorry. Okay, I'm prepared. Anyway, the plaintiff knew that they had to establish it. They brought it. They told us that they were going to establish it. We raised the issue. It was framed by the pleadings. When they realized, and I still am hearing, and I hope the justice can see this, what they're suggesting is they're going, well, we knew that they were going to bring it up, so we just decided it was a red herring. It didn't matter. What? If the basis for your standing is that you are in fact an agent of the real party in interest, or else Rushmore or the law firm could have been the plaintiff, I guess. But if your basis for standing is that you are an agent, or that you're the real party in interest, and that your agent is holding the note and the mortgage, how could that not matter? How could the actual plaintiff not matter? Then the agency relationship is completely irrelevant. And this court has not held that, nor has any court held that. What some courts have held, including the Fourth, although I don't see any specific guidance from the Fifth on this, and I think I would like to think a certain way, but what it says that the involvement of an agent does not necessarily diminish the standing, and we don't disagree with that. But there is absolutely no evidence that the new plaintiff was represented or was the agent of Rushmore. None. There's actually no evidence that was admitted that Rushmore was the servicer for the first plaintiff, because they abandoned their first 4 exhibits on the basis that there was then a substitution. Look, I think that to look at it this way, what the bank says is This is one of those trust us, we're a bank theories. Hey, we're the servicer for everybody. It's okay. It's just a name. It's just Wilmington. It's just US Bank. And then it's also just a trustee, and it's just substituted in. Well, look, that may or may not be true in terms of whether or not who is the named plaintiff, but they still have to establish the agency relationship. When we raised it, they completely abandoned that idea. And I guess I'll conclude with this. If there was no prejudice, if it didn't matter whatsoever, then why did the plaintiff do it, and why did the court grant it? That if it didn't matter, then let us try the case that everyone was prepared to try, instead of, what I say in the reply brief, torpedoing what we were there to do. What I'm hearing from the plaintiff is that it didn't matter, so therefore we just decided to do it. Well, but look at it the other way. Either they didn't know about the change, they being the servicer, they being the plaintiff, they being the plaintiff, the servicer, and the law firm did not know that their loan, that they were the real party interest, had been sold to somebody else by somebody else in a different state. Either they didn't know, in which case that is troubling for their idea of the actual agency relationship and constructive possession, or they did know and they wanted to just wash it over the court's mind. And I put in the brief that I don't think that the law firm did that. I think that they didn't know. And they didn't know because the servicer didn't know. And the servicer didn't know because the plaintiff didn't know, because they weren't the real party in interest. Somebody else was. And yet, so either it goes, the notion that, I understand what the court's saying, that it does not necessarily matter who files the lawsuit. If they're holding an endorsed, a negotiable instrument endorsed in blank, then that's all you need to know. I would necessarily agree with that if it was a case that was pled that that whoever was foreclosing had involvement in the loan. Here, we don't have that. With that, I'd like to take any questions if the justices have any.
Are there any other questions from the panel? Otherwise, the time has expired. All right, we have no questions. We thank you all for your arguments, and we are in recess. Have a great day.
Thank you, Your Honors.